And with that, the first case on the docket is Florida Wildlife versus Department of Community Affairs.
Police Department, I'm Thomas W. Reese. I'm representing the Collins Florida Wildlife Federation, Friends of Matanzas, Patrick Hamilton, and William Hamilton. And I'd like to reserve 6 minutes for rebuttal, please.
All right.
This appeal involves a very important case concerning the town of Marineland. It is a very small town on a coastal high hazard area. It's an environmentally sensitive area. There's very good water quality. It's an estuarine research area. There's 14 miles of publicly owned land in this particular Matanzas river area adjacent to the town of Marineland. And the important issue that's raised is this being entirely within the coastal high hazard area and the town completely renewing or readopting their comprehensive land use plan. The question is, does the Department of Community Affairs have to follow the statutory and rule directions, which we contend are unambiguous, that says that they have to consider the best available data analysis that exists? In this particular case, we presented the data concerning hurricane frequency and severity that comes from sources such as the National Hurricane Center. It also comes from sources from research by universities, documents and data has been presented at Florida hurricane seminars. In this particular case, the Department of Community Affairs said that they did not have, were not required to, and did not have to consider that type of data, that they'd have to be instructed by the legislature in order to do that. We contend that the legislature has already instructed them to do that. That it's stated in several different sections that they have to comply and adopt and implement the best available data analysis, particularly section 163, 31778.
Now, does that cut both ways, i.e., after a year like this where there were no hurricanes that hit, if there was data that showed the trend was going the other way, could they loosen the restrictions in the plan?
The best available data would be that you would look at this in scientific basis on what does the data tell you. You're not really looking at one-year trends. You're looking at long-term, decades.
Long-term trend turns the other way. It cuts that way, too. They could loosen the restrictions if they had scientific data that said hurricane activity was now decreasing rather than increasing.
We would take the position that they would, if the data showed that you're actually in 10 to 20-year cycles, that it would instruct you that it's going to come back in another 30, 40 years, and it's not a good idea that there'd be something that you'd be looking at on whether you should actually be putting that type of density in the coastal high hazard area. If you're actually doing, and it's our contention, that's what the data actually shows, that you're going through almost 20 to 30-year cycles based on the temperature in the Atlantic Ocean on hurricane frequency and severity. And it would not be good comprehensive land use planning to try to say, well, we're in a hollow right now, let's put it there, knowing that you're going to get another high and the frequency is going to increase. But in this
How is frequency relevant? If you're going to, if you predict scientifically that you're going to have 4 storms versus 6 storms, how does that change your comprehensive plan? Does it change how your building standards are? Does your density change because you're only going to have 4 storms versus 6 storms, for example?
The density is, really, in our opinion, it's a matter of probabilities. Where is the hurricane going to hit? You're going to have more probability. The data is also showing that the hurricanes now have higher intensity. And the department has actually recognized this, and the legislature has also recognized it, and they're instructing that you plan for Category 3 hurricanes. It's possible you get a Category 4 or 5. But it's all a matter of, we don't know exactly what's going to happen, but how do you use that data to show you what you should be doing? And yes, you would reduce your density. You would also affect your building standards, because the density has an effect on hurricane evacuation, hurricane shelters. It has an effect on how many buildings are going to be there.
But what I'm trying to understand, for example, evacuation. Is it a different standard if you have to evacuate for 3 storms or 5 storms in a year? Or would the evacuation, how would the evacuation plan be different because you might have 3 versus 5 storms, for example?
We contend that it's important and it's a factor that you'd use because the number of times that you would have to evacuate affects how much density you would want in that particular area. Because if you say that we have a lower probability of hurricanes, you might put more density in a coastal high hazard area.
But if you have a plan that allows you to get everybody out within an acceptable amount of time, what difference does it make if you're getting them out 3 times or 5 times as long as the plan is set up so that you can get them out in an acceptable amount of time?
Well, in this particular case, we don't have that situation. The data in the record shows that that hurricane evacuation times would be increased.
I understand, but I'm trying to understand the relevance of this frequency argument. And you said for things like evacuation plans. So I don't understand how evacuation plans would be affected by your predicted frequency or your complaint that they didn't look at some documents which might have shown increased frequency or increased intensity, for that matter. If you can evacuate from a 3 versus a category 2 or a category 4, what difference does it make?
It all goes into a factor of how much density you're going to put there, because the density affects your ability to get the people out and to shelter them when they do get out, if they get out. And in this particular case, the evidence shows that that has not been established, that there really is going to be a decrease in the evacuation time. It's going to take, or it be an increase in evacuation time, and there's a deficiency in the number of hurricane shelters. So all that figures in. There is no one data point that says this is what you should do, but the question here is, can the Department of Community Affairs say we're not going to look at frequency or severity, period, unless the legislature tells us? We contend that the legislature has already told them that it's very clearly said you use the best available data. And the question really isn't how you use the data, but that you use it.
Assuming it's relevant, right? You have to show it was relevant data, correct?
Correct.
And that's what I'm still struggling with. If you have inadequate shelter space, presumably it's going to be inadequate whether you have to use it for 3 storms or 5 storms in a year. So why is it relevant to require the use of that data?
If you're going to have more severe storms, you actually have to evacuate a larger area. Hurricane Category 1, you'd only evacuate the Category 1 areas. You get Category 2, 3,
This area encompasses more than one area? This isn't an area that would be evacuated in any kind of storm?
The entire area is in coastal high hazard Category 1. So even in a Category 1 hurricane. But the question becomes, they're going to evacuate anytime a hurricane is predicted to hit that particular area of the town of Marineland. But if it's a bigger hurricane and more intense hurricane and they're evacuating a Category 4 area, that means possibly entire counties are going to be evacuating. It's going to take longer to do it, and it's going to take more shelter. So the frequency and the severity of the hurricanes is a very important factor deciding what density should be used there. But the question here is really the more narrow question. Did the legislature already say you have to use this data? You have to look at it. You have to take it into consideration and address it. You can't just ignore it. And that's what we've done here. They just ignored it, and they said we're going to ignore it until the legislature tells us that we have to look at it. We contend the legislature already has, and there's number, and their rules have said it. Not only, and it's one of the compliance criteria. The definition of incompliance actually states that it includes Section 163, 3177 criteria and Chapter 9J5. That is where the data analysis requirements are situated. They're in 163, 3177A and 10E. They're also in 9J5, 005, 2A, and 2C, which the department wrote those rules. They have to comply with their rules. They can't just say we're not going to comply with the rules because the legislature didn't tell us. The reason they adopted the rules, the legislature did tell them, and they recognized it.
Was there any dispute below about the reliability of this data? And was there any of their argument, we're not going to use this because we don't rely on it, we don't think it's reliable, or was it simply we don't have to use it?
It's simply we don't have to use it. The document was actually introduced, evidence was introduced into the record number documents. They're on the record on appeal. There was not any contention It's the National Hurricane Center that says that this hurricane frequency is increasing. We also presented evidence from private insurance companies who have done analysis on hurricane frequency and severity. That's how they determine their rates. We actually tried to introduce evidence on whether they'd actually issue insurance in the town of Marineland, and the answer is no, they wouldn't, but we couldn't get that evidence in. We contend that.
What was that evidence? Was that your expert who talked to one person?
Correct.
Is that my recollection?
It would have been, but this is Administrative Procedures Act. It's any evidence rule, and hearsay evidence is admissible if it's supported by non-hearsay evidence. We contend that this was merely a hearsay evidence that was supporting evidence that was already in the record concerning the suitability of town of Marineland for the type of density that's being proposed.
Was it excluded on hearsay basis or on some other basis?
It was excluded not on hearsay, but on not being relevant.
Let me ask questions about standing, and I guess we'll begin with the Hamiltons. And I'm having a difficult time understanding how they have standing in this particular case. I'm having a difficult time understanding that the allegations that are raised to show that they have standing or not supported by the evidence in the record, or that they don't exceed the degree of interest of the community as a whole. So could you explain to me, begin with him, and tell me how they have standing in this case?
The Hamiltons both were found by the recommended order and final order to have standing in the proceeding below, that they operated a business within the town of Marineland. They had a... How
would their business be uniquely affected as opposed to all the other businesses in the town?
Well, we presented evidence both that they had standing as for operating a business within the town, but we also presented evidence that they had standing under 120.569 as having their substantial interest affected. And we contend you can have standing both under 163.31841A as an affected person as it's defined there. And we also contend that definition says include. It's not limited to whether you own property or operate a business or live within a town, because we have an interesting situation here. There's only 6 people live in the town. But yet what that town does affects everybody around them.
So every business owner in every town has standing to participate in one of these type proceedings? Is that your argument, or does there have to be something more than owning a business?
The Florida Wildlife Federation was found to have standing in this case because they operated a business within the town. They were also found in the St. Johns County case by final order of the department that they had standing. They don't just operate occasionally there. They are there frequently.
My question is that enough? Does anybody who owns a business in the town in your position have standing?
The way I read the statute, it's our position, that's what the legislature said. That if you own or operate a business, they were trying to broaden standing, and that's the way what the statute says. It also says includes. And we contend that it says include because when they adopted that statute, there was already standing under 120.569 for any person who had a substantial interest that was affected. To try to say that somebody that lives outside a small town.
I know, but in order to show that the person is adversely affected, the interest must exceed, the interest of the community as a whole. And it would seem to me you would have to establish something unique about that business that would make it suffer more or in a different way than the other businesses in the community. And that was just one example that I didn't see. You also talked about the increase in traffic on A1A and a lot of other factors that I thought were either not supported by competent substantial evidence in the record or were factors that affected everybody generally anyway. And I'm struggling to determine how the Hamiltons and the other parties have standing in this case.
My clients are affected differently from other people in St. Johns County or the general area around the town of Marineland because they're actually there on Crescent Beach. That's where you evacuate up A1A to get the bridge over 206, Highway 206. That's where they're located. That is their evacuation route. That's different than if you live up in the northwest corner of St. Johns County, because that's not your hurricane evacuation. It also affects their hurricane shelters. Which ones are they going to? And we contend that actually once you start getting a Category 4 or Category 5 hurricane evacuation,
Didn't the
it
evidence,
affects everybody.
actually show that the hurricane evacuation times have actually decreased in the surrounding area, and that, there really wasn't any evidence to support, that particular theory that you're advancing? Isn't that basically correct?
The comprehensive plan said that it was not to increase over 12-hour hurricane evacuation, and the data showed that it had not, but it did not show it had not increased. Actually, if you project out what the hurricane evacuation times are actually going to be, this is going to adversely affect it, because you're actually putting over 600 cars on that road. And so if the difference is really, if this is approved, are there going to be more cars on the road? The answer unquestionably is yes. It's going to adversely affect us. More cars, we don't have to, for standing purposes, we don't have to show that they met some previously adopted level. All we have to do is show that this is going to adversely affect us. And we also...
What do you have to show to establish that they've been adversely affected?
Excuse me?
What do you have to show to establish that they've been adversely affected?
If they have a substantial interest, then it's going to be adversely affected. Here,
doesn't the person's interest, the party's interest must exceed in degree the general interest in community good shared by all persons? If we look at the provisions of 163, 3215, 2A, is that not what it requires? If we look at Florida Rock Properties versus Keyser, I mean, isn't that basically a requirement to make that showing?
Yes, you have to show that they are actually going to be impacted, and it's just not an abstract interest in what should be done in coastal high hazard areas. This is actually going to affect their evacuation times, their hurricane shelters. It's going to affect their insurance.
It's going to, for example, the Hamiltons, it's going to affect them in a unique way because they own a business there, and all the other businesses are not going to be similarly affected.
When the situation in their business, the evidence was put on there to show what they had actually done within the town itself as a business. They had actually done property transactions and helped acquire land for the River to Sea Preserve. They'd helped acquire land that's an island owned by the town. They've done quite a bit of business activity and continue to do business activity, and that was to go under the 163, 3184.
I mean, another example about the oysters and the oyster business and the kayak business. What evidence was presented to show that that business, that the water quality was going to degrade and that business was going to be adversely affected or impacted? Well,
the Hamiltons both testified concerning those two businesses. That the oyster lease and the location is there just north of the town of Marineland. Also, one of the members of the Florida Wildlife Federation actually owns the lease that's within the town.
I know, but didn't the evidence even demonstrate that the town plans to improve the quality of the local water bodies and that the plan recognized that?
The evidence shows that they are proposing to do outstanding Florida water stormwater treatment levels. But the evidence shows that they're actually going to put more density there. It doesn't show that there's going to be an improvement in water quality. It's just they're going to do more water quality treatment than normally is required. The evidence was presented that what happens when you actually do have a hurricane, and the expert witness testified with regard to what happened to Apalachicola Bay and how actually they had a red tide outbreak and they had to close the shellfish harvesting for 3 to 4 months as a result of the hurricane, which hit over 150 miles away. So that shows how the water quality is affected by areas being flooded.
A lot of these same factors apply to FWF too. I mean, I'm just having a difficult time either finding that there's evidence to support these standing claims or that they're just not adversely affected according to the definition as I understand it.
Well, with regard to standing, the recommended order and final order found that we had standing, and that was not appealed. That's not an issue on appeal.
But
now, the issue is, do we have a standing here under 168?
That's what I'm trying to do.
So we are a party and our interests are adversely affected. And that's all we got to show. And actually, the Florida Constitution says that any injury, and we contend that to try to limit standing under 12068, you have to comply with Article 1, Section 21, and you have to do it by the least restrictive means possible. Why would you keep people whose interests are adversely affected from having access for the first time in this situation to the judicial branch? We've been in the executive branch. We have a right to go to the judicial branch, which is this court. And my time is...
Your time has expired. I will give you 2 minutes for rebuttal, though, and add
Thank
it to the other side's time as well.
Good morning, Your Honors. May it please the Court. My name is Dennis Thayer. I'm counsel for the town of Marineland. I'm also joined at council table with Shaw Stiller, representing the Department of Community Affairs, David Ashburn on behalf of Centex. Your Honors, we have divided up our argument briefly. I am here to discuss a bit of the history of the planning process. Based upon the questions I've heard already this morning, I don't know how much of that history you need, so I will summarize it as briefly as possible and turn it over to my co-counsel on this matter. As found in the findings of fact and recommended order, the town of Marineland is extremely unique. We were given an opportunity due to circumstances related to the tourism industry and the decline of the tourism in Marineland in the 1970s and the 1980s to basically start over from scratch. And it's described in the recommended order and the briefs provided to you all for your consideration about how that planning process started. We were provided with a grant from the state and had the town designated as a remarkable coastal place. Workshops were conducted, a committee of what they refer to as stakeholders was created, and we didn't rely upon our own staff because with a town of a population of 6, you can well imagine we didn't really have the staff. So we brought in the experts from the Northeast Regional Planning Council who served as our planning staff. We had meetings with planners from both St. John's, Flagler counties. We discussed a lot of the issues that are presented for your consideration this morning, a lot of the technical issues. We first came up with a vision of what we wanted the town to look like. We wanted it to be a sustainable community. And as you can see from the history, predating briefly this remarkable coastal place designation, we had actually put 85 of our 150 acres into a conservation designation, the River to Sea Preserve, which was purchased with state funds, which protected the most sensitive...
Do I understand that you're just going to kind of cover the history and your co-counsel is going to get into the standing issues?
Yes, Your Honor, and I'll provide a little bit of the facts on the standing while we concur with that there is not standing, but Mr. Stiller will deal with the evacuation questions, the hurricane frequency question that you've heard, and as well as the standing issue. So again,
the only standing issues that are before us are whether or not the lower tribunal was correct in deciding those that didn't have standing. Correct.
That is correct.
You're not arguing that anybody that the lower court found had standing doesn't have standing. Is that correct?
That is, for the town's position, that is correct, Your Honor. So essentially, we undertook this planning process. We designated significant areas and actually placed them in permanent conservation uses. The University of Florida Whitney Lab, which is a marine research center, has expanded its operations. And then as far as the technical criteria, as the court has pointed out, we have designated the entire town limits to be required to meet the Outstanding Florida Waters designation, which is the highest stormwater runoff protection that you can provide. We've protected what remain of our sensitive hammock areas that are not included in the River to Sea Preserve. We've otherwise tried to manage and protect the conservation issues that you've heard about today. And as far as hurricane issues, we've dealt with the evacuation standards as Mr. Reese pointed out, being that the entire town is in a coastal high hazard area, if there is a Category 1 hurricane that approaches the entire town, must be evacuated. So we cannot provide shelters within our own town. We've agreed to work cooperatively with our adjacent, since we're in 2 counties, with both St. John and Flagler counties, to meet those shelter criteria that we're required to meet. And then our next step, now that we've adopted, or assuming that the comp plan goes forward, we will then be adopting our land development regulations, which will deal with the issues concerning how storm-proof the buildings must be, what their elevations must be, and issues of that sort. So those are issues that will be addressed in our land development regulations. So I don't know if you all have any other questions about the background, but I will turn it over to co-counsel to deal with those technical issues. Thank you.
May it please the court, as Mr. Bear mentioned, my name is Shaw Stiller. I'm the General Counsel for the Department of Community Affairs. I'm here to address the hurricane standing issues with your honors. First, turning to the hurricane issues, it is not entirely true to say that the department is not concerned with the intensity of hurricanes or the frequency. We're very concerned. In fact, one of our divisions is the Division of Emergency Management, the people you see on TV when storms all too frequently strike our state. And the legislature has instructed the department to plan by intensity, but not by frequency. Let me explain what I mean by that. We have different protected zones, and protective zone doesn't appear in the statute. That's something I just came up with. But the first one is the coastal high hazard area, and that's defined. It was defined when this case was brought as the area that's evacuated during a Category 1 storm. It's since been revised to be defined as the area that's inundated by, projected to be and modeled to be inundated by storm surge during a Category 1 storm. I don't think that changes the town of Marineland's position at all. During that, in that area, the department, through its planning process, is instructed to undertake the hardest look at what's happening there, to be sure that those people can get out and evacuate, and to be sure that there's reasonable shelter available. We also plan for the Category 3 storm, which is noted in footnote 11 of the recommended order, as the most probable storm. And for the hurricane vulnerability zone, which is what we refer to as the Category 3 evacuation zone, we ensure that those people can get out in a reasonable time.
Was the data that was excluded as not being relevant that the opposing counsel talked about, did it relate to intensity or only to frequency?
I believe the only evidence that was excluded was windstorm insurance. The data regarding the cyclical and the uptick that we're in right now regarding hurricane frequency and intensity was actually admitted. Administrative Law Judge Johnson wanted to take it and take a look at it and then base his ruling upon the evidence. His ruling was that the department has consistently not considered it and considers that a matter for the legislature, which of course was adopted in the final order. It's important to note, and also, that the department doesn't stop at Category 3, but all the way to Category 5 now.
Was the uptick information, as you refer to it, the cyclical information, did that relate to intensity as well as frequency, or is that just frequency data?
I think it was more telling, as I recall, as to frequency, but the same water temperature and Gulf Stream patterns that would support more frequent storms are also thought by those who do these studies to increase the intensity of the storms. 2 sessions ago, the legislature has also directed us to start thinking about Category 5 storms, the least probable yet most destructive storms. They amended the coastal management element of the statute and are now directing counties, when they are putting population in the coastal areas, to maintain an out-of-county evacuation time of 16 hours for Category 5 storm, unless another time is approved, and also to ensure that people can get to shelter in 12 hours in the event of a Category 5 storm. So the legislature has spoken on this issue, but it has directed us to, in essence, draw these tiers or zones and plan accordingly, to plan as though a Category 1, 3, or 5 may hit tomorrow. Or maybe, unfortunately, perhaps more than one would hit. I mean, we have 28 coastal counties who are doing this planning, and again, the legislature is fully aware of it, as indicated by every couple of years they amend the statute. Getting down to the basic legal requirements of data and analysis, it's important to read the rule 9J5. It's 9J5.005 sub 2 sub A, and it tells the department to look at relevant and appropriate data. And with respect to the frequency of hurricanes, the department has never taken the stance that we should plan more when there are going to be frequent hurricanes, and then perhaps sit on our haunches when there might not be frequent hurricanes. And of course, you can see the logical flaw in that is there might be frequent Category 1s, and we're planning away, and then we relax, and there's an infrequent Category 5, and we're caught sleeping, and that's not what the legislature has directed us to do, and that's not what, in fact, we do in practice. Let me turn quickly to the issue of standing. Judge Sawaya, I heard you mention Section 163.3215 as part of standing. I just wanted to note that the standing provisions in that statute apply to challenges to development orders in circuit court. And so what we were dealing with below is standing under 163.3184 sub 1 sub A, which defines affected person. And it's a very broad grant of standing. It does, in fact, grant standing to anyone who operates a business anywhere in a local jurisdiction that adopts a comp plan. It affords that same broad standing to people who reside or own property in the local jurisdiction, the only additional requirement being that they have to submit an oral or written comment to preserve their standing. The appellants are arguing that that definition should be broadened and that we should give standing below to entities that, like Friends of Matanzas, who don't operate businesses within a local jurisdiction but might operate a business elsewhere. It's our position that the legislature has clearly spoken on the issue of standing. There's a specific list of those who have standing, own property, reside, operate a business within the jurisdiction. The legislature has made two exceptions, one for an adjoining local government, and secondly, if someone owns property in one jurisdiction that abuts property in another jurisdiction that was granted a future land use change. So the legislature seems to recognize this exclusive list and provided a few exceptions. And it's our position that the First District Court of Appeal has affirmed this approach in the St. Joe Paper Company case. In that case, the governor and cabinet actually found that 1,000 Friends of Florida had standing in Walton County based on the fact that they participated in the planning process. The First District Court of Appeal reversed and said in no uncertain terms that the definition in 163-3184 is a, quote, statutory catalog, and that to expand beyond that statutory catalog is, quote, without appropriate legislative guidance. Those are the only issues I was going to address today. I was going to leave the rest of the time to Mr. Ashburn unless the panel has any questions. Thank you.
Do the Hamiltons have standing?
We are not contesting the Hamilton standing. They had standing below. Appellates, Centex, they are contesting appellate standing. The department is not.
Okay.
Good morning. May it please the court, I am David Ashburn, representing Centex Homes, doing business with Centex Destination Properties. Following up on the standing issues that have been raised here today, I'll do that in a moment. But first, I feel the need to also track back to where I think we are on a global basis in this case, and that is to look at what is the burden of the folks who have initiated this case in the first instance. They were required to demonstrate that the comprehensive plan amendments were not in compliance. Our view is that most of the issues that they have raised are not compliance issues. But even apart from that, the administrative law judge found that the compliance had been demonstrated by competent substantial evidence. The backdrop against which that must be observed is that in the administrative proceeding, the parties on this side of the room presented multiple experts in specific areas that not only included the land use principles, but as well testimony from experts in hurricane planning and evacuation matters. Indeed, the gentleman who testified that hurricane evacuation issues should not prevent the going forward of these comprehensive plan amendments is actually the gentleman who created the model for determining some of these evacuation issues. So what I find interesting is throughout the arguments we've not heard arguments from the appellants that the administrative law judge or even the Department of Community Affairs got it wrong because the findings were not supported by competent substantial evidence. Instead, it's that we got it wrong because they had a better argument. Your Honors, even if that were the case, that one might be able to, in hindsight, look back and disagree with what the judge may have said, Chapter 120 prevents a reweighing of the evidence at this point. And so those competent substantial evidence supported facts that were found by the administrative law judge and subsequently by the Department of Community Affairs must be upheld. Those facts also are important to this very standing issue that we've discussed this morning. It is correct that we have not appealed the findings of the administrative law judge and the Department of Community Affairs concerning the standing below of the appellants. But it's also important to note that one of those appellants was not found to have standing, and that was the Friends of Matanzas. We believe, Your Honors, though, that this issue of standing on appeal is extremely important, and that
Well, who do you say does not have standing in this appeal?
we don't believe any of the parties have standing on appeal. The standing on appeal is not dependent, as has been discussed, simply on being a party below. They do have to show some kind of substantial adverse effect. All of the bases that have been offered by the appellants for their substantial adverse effect track back to their contention that was rejected below, both at the administrative law judge and the Department of Community Affairs level, that these comprehensive plan amendments increase density in this area. And it's clear from all the findings of the judge consistently below that these comprehensive plan amendments do not increase density in this particular area. The superficially attractive argument that the appellants have tried to make is, after all, there are currently only 6 people that live here. That's not the issue, and it's not the issue, as even their own expert conceded in testimony below, that in these kinds of proceedings, when the effort is to determine whether there's an increase in density, it's appropriate to look at the comprehensive plan amendment that's in place. Because, after all, if we leave here today and it were determined that comprehensive plan amendments were not in compliance, the town is left with the comprehensive plan that is in place that allows for a density that is much greater than what would be in place if the comprehensive plan amendments are allowed to go forward. And Judge, if you take each one of those arguments, all these issues about evacuation times, water quality, they all go back to this issue of there's a greater density. Once it's concluded, and these findings again are supported by competent substantial evidence, that indeed there was no increase in the density, there is no adverse effect left.
Wait a minute, do I understand your argument to be that they don't have standing on appeal if, based upon the factual findings below, it's determined that they're not substantially affected?
That's demonstrative of that fact, because at some point they have to demonstrate that there is substantial.
But if they want to challenge the factual determination below, that they weren't substantially affected, you would concede they have standing on appeal to do that, wouldn't you?
If they are able to overcome findings of fact by virtue of a demonstration that indeed they're able to demonstrate that there is a substantial adverse effect and overturn those findings, then they find themselves in the position of having demonstrated substantial adverse effect, and yes, indeed, they would have standing. But, Judge, they have to get over that. They have to get over that threshold of demonstrating that they have been substantially adversely affected.
It sounds like almost a reverse of the usual argument, i.e., if I lose on the merits, then you say I don't have standing. Normally, the standing is something you decide as a threshold matter, but how could you decide that threshold matter if their standing is dependent upon some determination on a merits?
Well, and Judge, that is a difficult situation that the court below always has in its consideration of the case, because in the consideration of the case, there's not the required, as Mr. Stiller, and we would agree with Mr. Stiller, below they're not required to demonstrate that substantial adverse effect. However, to get to this point, there must be some demonstration. So, yes, Judge, I agree there's sort of it's something of a chicken and an egg kind of situation in that the factual underpinnings of the case are what are ultimately going to determine standing. And they are here before you today. We would argue that they have to first cross that threshold question. Before they get to any of the merits issues that they want to raise, they have to cross that threshold issue of demonstrating that they have been substantially adversely affected. And to do that, they've got to demonstrate that those findings that the judge has reached below have to be overturned. Factual issues that are, if supported by competent substantial evidence, must be upheld. And in fact, therein lies the rub for the appellants. Although, if you go through their briefs, they consistently make the argument that all we're trying to raise are legal arguments. We're not trying to overturn findings as being unsupported by competent substantial evidence. These are pure legal issues. In fact, what gets them in this courthouse door is a demonstration of those factual issues, which they failed to carry that burden. So we don't believe they can get through that particular door.
You have some cases cited in this section of the brief for the principle that standing on appeal is narrower than standing below.
Yes, Judge.
Factually, are those cases where the courts held somebody didn't have standing on appeal, where they did have standing below?
Yes,
and if so,
Judge.
what kind of factual situations were they?
Well, you can have a situation, for instance, where you can, and actually this statute gives the best example, although DRI statute gives good examples as well, where the courts can allow broad public participation in this formulation of a decision. But the legislature has the ability to say, you may have had ability to participate below, but that's in that formulation process. You don't have the ability to continue to participate. The DRI statute is a good example where, in that case, the statute specifically says who may appeal a decision, and the courts have said that that's appropriate for that to occur. I did want to go back real briefly, and I don't know if it's a particular concern, but I was concerned with the constitutional argument that's been raised in this case, that there's an access to courts issue. Simply is not an access to courts issue in this case. Access to courts, that particular provision of the Constitution, has been construed to preserve access to courts when that access...
Well, let me make sure I get this straight. These appellants were found to have standing below, right?
Yes,
All right. And then your argument is that once they get past the DOC process and they want to come to the district court to appeal, they've got to make this other showing pursuant to the statute of being adversely affected. And then we have to go through, the appellate court has to go through that analysis to determine whether once they pass the proceedings below and have gone through DOC, whether they can continue to litigate those issues here in this court. Is that basically?
That's correct, Judge. Because of and again, I agree with Mr. Stowe, the very broad nature of the standing that's accorded in 163.3184. It may sound burdensome to the process, but I would agree. If you demonstrate that you reside in the town and you submitted comments as required by the statute, you have standing. But that doesn't create the adverse effect that's required to get you to the next step.
Okay. Thank you, Counselor. Your time's expired.
Thank you.
I'd like to briefly direct comments to three subjects. Number one, we did file requests with the administrative law judge to make findings on evidence we had submitted with regard to standing under 120.68.1.
I think if I read the order correctly, that he didn't want to go there.
He didn't want
so
to go.
he didn't decide those issues.
I would respectfully suggest that he should have.
Well, why should he decide the issue? Shouldn't it be for this court to decide whether, based on what we see in the record, whether they're standing for you to come here? Based on, the way the standing issue has been framed by the legislature in the prior cases?
He's the trier of fact, and his responsibility is to make findings of facts. That's the function he performs for the Department of Community Affairs. I just respectfully suggesting it would be a benefit to the appellate courts. As far as the comment about whether density has been increased or decreased, that brings up the other issue that we had raised. The 1992 comprehensive plan and the density in that is not a benchmark. It's not a compliance criteria. The department has no authority to treat that as a compliance criteria, and that's what they did. They tried to say what density was in the 1992 plan, and does this increase it or decrease it? That is not the criteria. It was improper criteria. The statute says that you're supposed to look to see whether the density being proposed is suitable. You don't look at the prior density. There's no legal right to that prior density. and it just is a bogus issue and improper interpretation of law in our opinion. And also, we presented evidence that shows that under the 1992 plan, you can't even do a reasonable calculation of what the density actually is because it has an unlimited number of apartments over retail. There's no cap on it. As far as the frequency and severity of hurricanes, if you had a Hurricane 1 that's heading towards the shoreline or the coastline, no one knows whether it's going to be a Category 2 or Category 3 or Category 4, or whether it's going to turn into a tropical storm. So that does have the frequency of these type of storms coming is a major issue, because you have to, if you're the hurricane center, you have to decide, are you going to evacuate that coastline? You have to try to predict what the hurricane's going to do. Hurricane Charlie is an example people don't know. I live in St. Petersburg, and we were told there was going to be a direct hit on us, and all of a sudden it made a right turn and it hit Punta Gorda because it had a tight eye, moved quickly. The effects of flooding were different than the windstorm.
Okay, thank you, Councilor.
Let me ask one more question. I have one more question for you, and I guess it's a matter of standard procedure and practice. In cases similar to this, and in the proceedings below, are there normally findings made about appellate standing? In other words, in those cases, you know, are the decisions usually made below that, okay, we think that they have appellate standing to proceed in the district court? And are those findings usually included in the order?
No, they're not.
Have you ever seen that before?
No, I haven't. There is the Florida Supreme Court has said with regard to as-applied constitutional issues that you can present your evidence and they don't necessarily make findings.
Right, and so generally what happens in these cases is that those issues are bypassed. They don't deal with them, and they let the appellate court decide the appellate standing issues.
Correct. And the situation, one of the cases with regard to standing on appeal is actually one of mine for the Florida Wildlife Federation and Friends of Kansas from St. Johns County. I made the incorrect assumption when I presented evidence at the trial level that if I had standing under 163-3184, I had standing on appeal. So that's actually where some of these appellate decisions with regard to whether you have standing on appeal hasn't been.
So basically, you've never seen a case where the appellate standing issues were decided below. Have you all ever seen a case where that's been done?
No.
All right. Thank you very much.
Thank you.
Next case